Hi, I'm Janice Switlo. In today's episode, I want to quote from Tecumseh. His address delivered to William Henry Harrison at Vince in 1810. Why am I doing this? Because it pertains to all the deal-making and proposals and things that Canadian governments are trying to give effect to. And why it doesn't work. So he explains it better than I can in terms of his law. And that is this. Sorry, where I'm quoting this from, if people are interested, it's the North American Indian Chief's book. So let's begin. I am a Shawnee. My forefathers were warriors. Their son is a warrior. From them, I take only my existence. From my people, I take nothing. I am the maker of my own fortune, and oh, that I could make that of my native people and of my country as great as the conceptions of my mind when I think of the spirit that rules the universe. The being within, communing with past ages, tells me that once, nor until lately, there was no white man on this continent, that it then all belonged to native men, children of the same parents, placed on it by the great spirit that made them, to keep it, to traverse it, to enjoy its productions, and to fill it with the same race, once a happy race, since made miserable by the white people, who have never contented, but are always encroaching. The way, and the only way, to check and to stop this evil is for all the native men to unite in claiming a common and equal right in the land as it was at first and should be yet, for it never was divided, but belongs to all for the use of each. For no part has a right to sell, even to each other, much less to strangers, those who want all and will not do with less. The white people have no right to take the land from the Native Americans because they had it first. It is theirs. They may sell, but all must join. Any sale not made by all is not valid. Part do not know how to sell. It requires all to make a bargain for all. All native men have equal rights to the unoccupied land. The right, and speaking under his law, the right of occupancy is as good in one place as in another. There cannot be two occupations in the same place. The first excludes all others. It is not so in hunting or traveling, for there the same ground will serve many, as they may follow each other all day, but the camp is stationary, and that is occupancy. It belongs to the first who sits down on his blanket or skins, which he has thrown upon the ground. Until he leaves it, no other has a right. So, for example, as Indigenous nationals have been made to settle, in one spot on reserves, for instance. This is explaining how Indigenous nationals of that same nation from another part cannot come over and kick out their brothers and sisters from another reserve. He's speaking about that occupation of an area, a part of the nation's land. And he's pointing out, and I want to make clear, always there's this effort, because Canada continues to try to say everything's domestic now. You're just a domestic ethnic minority, but that's not true. The treaties still exist, the nations still exist, sovereignty has not been abandoned, the lands are still owned, and the responsibility for the land still reside with the Indigenous nationals. The Crown has been granted permissions in some areas. The reserves are actually reservations out of those permissions where full jurisdiction continues. So we have, if you will, because the permissions granted to the Crown allow for her to exercise partial political sovereignty. She does not own the land, the underlying title. She's given permissions of use. She's a tenant, if you will. Only a head tenant. So here's a trite basis, and I've said this before. The law that applies to a land, an area of land, is where that land is. Now, the Crown, not having been granted any permissions by the landowners, whose laws still apply to their lands, is simply saying through her domestic courts, I guess it's being asserted, okay? Sovereignty is asserted. When someone's asserting something, they don't have it. This is why I constantly remind Indigenous nationals not to say you're asserting rights. You're exercising them, okay? Because you have sovereignty. It's being interfered with, you're being oppressed, you're being occupied at places. All that, of course, goes without saying. But the fact is, you have it, you use it and exercise it, you don't abandon it. So, what does Tecumseh's address bring to mind? It's that the Canadian government seem to think that the only thing that has to be satisfied is their domestic law and doctrines and whatever else they put in place. So they say, contrary to the Royal Proclamation of 1763, we can accept something lesser now in terms of evidence of agreement. 25% plus one. If that doesn't pass, then, we can have a second vote, and it's only a majority of who shows up, and it can be under, and I'm talking about now the Child Welfare Acts, Bill C-92. And, there can be a variation of how things are done. And, that's actually under the Anishinaabe Nation Government Act agreement that I'll be dealing with soon. So my point is that even if Canada chooses to breach what is required to be met as established by the Crown and says, it's okay, we only need 25% plus one, etc., and we can have another vote and we can adjust how that vote's held. And that can mean, for instance, there's no notice and, one family's told and 8 people show up and they all vote in favor and boom, Canada thinks it's got a capitulation and an entrance under Section 35. The point of the matter is there's 2 bodies of law here. For any agreement to be binding on anybody in any situation, both parties have to comply with their authorities and the laws that govern. Okay, so not only is Canada not complying with what's in place that the Crown says I need to prove that I'm getting agreement and consent from the Indigenous nation via its nationals, but also for a deal to be binding and done, it has to comply with the law of the land. It has to comply with the law of that particular nation where the law is situated. And that law, Tecumseh speaks about part of that. A handful of us, one part of us, can't sell it. It has to be all of us. If it's going to bind all of us, and keep in mind, the Indigenous nations are not individual communities within the nation. It's not an individual Indian band. It's not that those small pockets. It's the whole, which comprises a very large portion of land. So Canada is paper trailing, getting these things signed. Chiefs are getting whatever they're getting, encouraging them to sign, and usually it's because they've been squeezed so tightly. And there's a episode I'm going to talk about next that deals with priming, and I'll explain that in that one. Why these things are being signed and how things are happening with that. The fact of the matter is that there's a whole portion of law that's being ignored. It's a portion of law that's not justiciable in Canadian courts. It's law of the nations with whom Her Majesty's governments need to enter into arrangements, and those arrangements need to comply with the original constitutional documents, being the treaties. Thank you.